Hey, everybody. I'm going to do my best to keep this super short and super sweet. What we have to talk about today is the reading assignment for class number 7, which appears on in your casebook on page 77 concerning more on institutions and procedures, the applicability of antitrust. We're going to talk about 2 cases, and I'm going to tell you what is the very simple black letter rule that runs through both cases. That simple rule is that antitrust applies. That is, regardless who the plaintiff is, regardless what they've done, antitrust applies. The statutory federal antitrust laws of the Sherman Act, the Clayton Act, and the handful of other laws that make up federal antitrust, they apply to quote-unquote trade or commerce. Okay, that language appears explicitly in the Sherman Act. Very similar language appears in the relevant Clayton Act sections. And there is no question that all of antitrust law applies under the same interpretation of that language. In other words, Sherman Act sections 1 and 2 and Clayton Act section 7, which are our most important substantive provisions, those apply in exactly the same categories of commerce as interpreted by the courts. And our 2 cases for today will tell us what that is. As I said, I'm going to tell you the super simple black letter rule, and that is the exchange of anything for value, for anything else of value is trade or commerce, period. So in other words, buying something with money or selling something with money, that obviously is trade or commerce. Doesn't matter who you are. It doesn't matter who the other party to the transaction is. Also, even barter. If I exchange something of value with you that happens not to be money for something that you give me that is also of value but not money, well, that's trade or commerce as well. And as we'll see, the theme in these cases in which the courts discuss what is trade or commerce is that the term is to be defined broadly. Doesn't matter what the parties' intentions are. Doesn't matter if a profit is made. Doesn't matter who the parties are, etc. The only limit, really, for our purposes, is that trade or commerce, even if some transaction happens to involve money or happens to involve something of value, trade or commerce does not include charity. All right. And maybe I should be cautious in the word that I choose. It's not so much charity in the sense of doing good works, but gratuity. That is, giving something for free, giving something without receiving consideration in exchange is not trade or commerce. Again, the purpose doesn't matter, the nature of the entity doesn't matter, etc. Okay, so pretty simple rule: exchange of something for value for something else of value, trade or commerce. Genuine gratuity, not trade or commerce. Simple as that. So let's look at the cases. We have 2 cases that both interestingly seem to involve what's people might call charity, but they come to very different results, and let's see why. The first of them is United States versus Brown University on page 78. Justice Department's been suing universities a lot during the last 20 or 30 years. Justice Department doesn't seem to think that the universities are very above board in the way that they work together on various commercial issues. And as far as the Justice Department is concerned, and so far the courts have agreed, what the universities do, that is, the service that they sell, the products that they sell to students, is trade or commerce. So providing education in exchange for money, trade or commerce, it absolutely does not matter that the service is quote-unquote education or is somehow special. The universities have often argued that, but they have failed to make that case. It also doesn't matter, importantly, that some of these entities are public. Like it turns out, public entities can, in fact, violate. I realized that Zoom just made me do a thumbs up, and that's because I think you're all awesome. Okay, so the fact that some of these entities might be state university entities does not necessarily matter. That raises a complicated issue that we will come back to at the end of this semester. It isn't actually irrelevant that a party might be affiliated with a state or federal government. in terms of whether its conduct can violate the antitrust laws. But merely being a public entity doesn't mean that your product is not in trade or commerce. So, for example, it is very conceivable that Cleveland State University could violate federal antitrust if, for example, say Cleveland State, which is a public entity, were to agree with Case Western University that we wouldn't admit the same students, or we would not charge any students lower than a fixed level of tuition or whatever. That likely would violate the antitrust laws, and it doesn't matter that Cleveland State is public. Okay. Relatedly, and Brown University makes this painfully clear, it does not matter if one or more parties to who are named as defendants are organized as nonprofit entities. You don't have to be a for-profit entity to be engaged in trade or commerce. You don't have to make a profit. In fact, you can sell at your own costs or even below costs and still be engaged in trade or commerce. Just doesn't matter. Okay, well, anyway, United States versus Brown University. Very briefly, the facts here are that several of the nation's most prominent universities, specifically the Ivy League universities and MIT, had a long-running agreement under which they would work together to decide how much each of them would give to every single student that they admitted in financial aid. Okay, they argued that isn't trade or commerce. Education might not even be trade or commerce. Moreover, all of them are organized as nonprofit entities, and they portray themselves as engaged in a public service rather than a business. Okay, well, they lose that. So let's think about, and by the way, a significant component of the case, and part of what made it certainly a harder case, and a case that made a lot of people sympathetic with the universities. I mean, it seemed like they were being punished for doing the Lord's work, doing good things, if you will. Okay, that is, they agreed in this arrangement that not only would they agree on how much aid they would give to all the students they admit, but they would only give aid to students who could demonstrate financial need. All right. Part of the appeal that the universities made to the courts, and part of the argument for why this was legitimate and not a restraint of trade, was that, on the surface, they are doing a charitable act. They are agreeing with one another that they will give benefits to students of need. And they're trying to, organize what they give to students of need or rationalize it or whatever. Okay, government says nothing doing, Charlie, and the Third Circuit agrees, and every court in the country would also agree. Because let's think about what the universities really effectively agreed in this case. They agreed not to give merit-based aid anymore to any of their students. So what did they really agree on? Well, they agreed on the price at which they would sell their product to consumers. And they made that agreement amongst themselves, even though they are horizontal competitors. Okay, so this was a horizontal price fixing conspiracy, at least as far as the government is concerned. They decided they would no longer compete on the basis of price, at least to the extent that price competition would be based on scholarships with any students except those who could demonstrate need-based aid. And as to need-based aid, they would agree on that too. They had protocols for deciding who could receive what aid. So the real problem in this case, and the reason that the government brings the lawsuit, is that the universities agreed not to compete on price for students. Students who couldn't demonstrate financial need would no longer be able to go to one university and say, hey, Harvard gave me a $10,000 scholarship. What can you give me? That just wasn't going to happen anymore. Okay, well, as we'll learn later in the class, the courts take this kind of thing very seriously. Horizontal agreements on price are ordinarily illegal. They're ordinarily considered the most serious antitrust violations. Something we'll see is that the court actually gave these defendants a break to a degree that most other defendants wouldn't get. Like in most other industries, people really could go to prison for the agreements that were reached here. The reason this thing wasn't held per se illegal, the reason it wasn't prosecuted criminally, is because these organizations are nonprofit and they're engaging. They're selling a product that isn't really just like every other product. We're going to learn a lot later on about how the courts decide when something is per se illegal and when it's not. So that's the break the court was willing to give these folks in this case. We're not going to treat you as harshly as we might if you were just selling nuts and bolts or toilet seats or bicycle seats or whatever. But the court doesn't give them a break whatsoever based on as to whether this is trade or commerce. It is. Okay, and again, a significant ruling in this case, which is now very clear, but may not have been quite so clear when the case was first litigated, is that the fact that these entities are educational in nature or providing a public service or whatever, and the fact that they're organized as nonprofit entities is irrelevant to whether the law applies to them or not. It might be relevant to substantive liability. We'll get to that, to whether their conduct is per se illegal. Whether it's trade or commerce, irrelevant. That they're nonprofit oriented, that they may have public motives, blah, blah, blah. Okay, that's Brown University. The other case we have to talk about is a funny case in a way, funny to me because it's I don't know, it's kind of a weird case, not quite the facts you expect to see in an antitrust case. But in any case, you have two nonprofit organizations in this case, the well-known Humane Society, which is being sued by another animal rights, animal welfare organization called Delta Rescue. And Delta Rescue claims that the Humane Society took actions to limit Delta's access to donations, to money donated to them by people who care about animal rights. Okay, none of the details of the Humane Society's conduct, their alleged conduct, is relevant because the issue for the court was whether this is trade or commerce at all. And you might say, well, it kind of seems like it because this is money changing hands. But the thing is, this is that exception, right? This is the exception that proves the rule. Giving someone something as a gift without the expectation of some consideration in return is not the exchange of things of value. And therefore, it is not trade or commerce. Okay? There's not too much more to say about it than that. This is just a nice example of a case that tells us where the limit is. Genuinely gratuitous gifts, not trade or commerce, period. Pretty much every other exchange of things of value, trade or commerce. Okay? That's it. See you next week. Have a great weekend.